Miguel Ángel, cuando empezamos. Perfecto, muchas gracias. Bueno, bienvenidas a todos. Voy a comenzar diciendo unas palabras en español. Agradecerles la participación en esta actividad. Este seminario va a ser en inglés, pero por supuesto, si ustedes tienen cualquier pregunta, mientras los expositores hablan, la pueden formular por escrito en el chat en español y yo la puedo traducir. ¿Ya? Así que en ese sentido no se preocupen. Y nuevamente agradecerles su presencia y comenzaré a hacer la presentación en inglés. Okay, so good afternoon, everybody. On behalf of the Faculty of Law, the Seminarios on European Law Studies, and the Masters in Public Law, we warmly welcome all of you to the seminar, The Prohibition of Violence Against Women Under International Law. This is the first of a series of seminars scheduled for this year, in which we aim to address the dialogue between Europe and Latin America on various topics in the field of public law. We appreciate a framework that explicitly defines violence against women in all its forms as a human rights violation. To reflect on this very interesting topic, we have the presence of two distinguished speakers, whom we thank for being here. Dan and Liliana Ronconi, thank you so much for being here, your time, and your presentation. I will give you a briefly introduction of, I'm sorry, I think there is, yeah. Okay. I'm sorry, yeah, there. So I will give a brief summary of their CVs, just to introduce you to the speakers. First of all, Sandesh Sivakumaran, who is a professor of international law at the University of Cambridge, director of the Lauterbach Center for International Law, a fellow of St. Edmund's College in Cambridge. Sandesh has published in a variety of topics in public international law. His work has been cited by, among others, the UK, Netherlands, the Colombian Constitutional Court, the International Criminal Court, the International Law Commission, and UN Commissions of Equality. Sandesh advises and acts as an expert of a range of states, international organizations, and non-governmental organizations. Sandesh regularly trains diplomats, members of armed force, the UN entities, and international law. And within all this work, he also has impacted the life of many PhD students and being a supervisor of a lot of us, including me, and has been an honor, honestly, to work with him. And also Liliana Ronconi, professor at Santo Tomás University in the campus of Valdivia. She's a doctor of law from the Universidad de Buenos Aires, Argentina. She's a specialist in school practices in Flaxo, Argentina, lawyer and professor in legal science, also as well in the Universidad de Buenos Aires, of course, and now as well works in the Santo Tomás University. She specialized in human rights, equality, education, gender, and legal education. Also, she works as a consultant on education and sexual education issues in Latin America. We thank our speakers for accepting the invitation to participate in this seminar, sharing their reflections and experiences with us. Speakers are kindly asked to know that they will have approximately half an hour to present, starting with Sandesh and followed by Liliana. And after the presentations, we will proceed to address questions from the audience via the chat. And you can ask questions, as I told you, in Spanish, and then I will translate in case it's necessary. Now I hand over to Sandesh Sivakumaran for his presentation on prohibiting violence against women and the international human rights law.
Everyone for attending, and thanks Daniela for the invitation and the very warm introduction. I'm going to try and share my screen. So if you can let me know when you can see my PowerPoint slides. Yep, it's up. Perfect. Okay, wonderful. Thanks. So as strange as it might seem today, the prohibition on violence against women under international human rights law emerged as a category only in the 1990s, so relatively recently. With some exceptions, violence against women came to be seen as an international human rights law issue only with the conclusion of 3 instruments. General Recommendation 19 of the UN Committee on the Elimination of Discrimination Against Women, which was adopted in 1992, the UN General Assembly's Declaration on the Elimination of Violence Against Women, which was adopted in 1993, and the Inter-American Convention on the Prevention, Punishment, and Eradication of Violence Against Women, which was adopted in 1994. And despite the importance of those 3 for really establishing the category of violence against women as an international human rights issue, we know relatively little about how those 3 instruments. So what I want to do in this talk is trace the processes by which those 3 instruments were created, and then turn to some of the key contributions. And so I'll focus on key features of the drafting processes, such as the role of experts, the influence of international women's human rights groups, and I'll talk about how the drafting processes fed off one another, but we're also in tension with one another. So the principal treaty on the Convention on the Elimination of Discrimination Against Women, does not an explicit reference to violence. At the time the convention was drafted, there was a proposal to include attacks on the physical integrity of women, but that proposal was not adopted. And the explanation seems to be that at the time violence against women was not sufficiently on the agenda of the international community to warrant inclusion of that reference. The closest reference we can see is to Article 6, which provides that states parties shall take all appropriate measures, including to suppress all forms of traffic and exploitation of prostitution. So CEDAW covers a subset, but not the broader category of violence against women as such. Now, despite the lack of explicit reference to violence against women, in the committee which monitors the implementation of the convention, regularly raised the issue of with states parties, but relatively few states reported on the issue. So partly because the convention does not refer expressly, and in order to encourage all states parties to report in 1989, the CEDAW committee, so the adopted General Recommendation 12 and so this is the middle column on the slide. That recommendation, General Recommendation 12, provided that states parties are to report on the measures they've taken on preventing violence against women. So with that General Recommendation, the CEDAW committee placed violence squarely within the competence of, and that's striking precisely because of the rejection of violence the inclusion when the convention was being drafted. But it's also striking how quickly states to the committee's position between 1989, when General Recommendation 12 and 1991, and the committee took up the issue of violence against women. An additional 24 states information presented information to the committee on violence against women. And at its session in January of 1991, the committee decided to allocate part of its session in the following year to an analysis of violence. The committee wanted to be active. And it was chosen in anticipation of the World Conference on Human Rights, which was scheduled to take place in 1993. And one of the members of the Ciclo committee, Elizabeth volunteered to prepare a draft general recommendation on violence against women for consideration by the committee at its 1992 session. In the meantime, in 1990, the president of the Inter-American Commission, now we're in the first column, the president indicated that the Inter-American Commission had discovered that the question of violence against women is not present in any existing convention, and that perhaps the time has come to prepare a convention on the subject. So accordingly, the Commission convened an Inter-American consultation took place later that year in July, and the consultation recommended the drafting of an Inter-American Convention on the subject. Separately, and moving to that at the UN Commission on the Status in March 1991, Canada introduced a resolution. Canada was keen to initiate a process which would lead to the adoption of an optional protocol to CEDAW. It was intended that that optional protocol would be developed in time for the 1995 World Conference on Women, which was to take place in Beijing. And that initiative arose independently and separately from the CEDAW Committee initiative and from the Inter-American Commission initiative. Canada's rationale was that CEDAW does not specifically address the question of violence against women. So that's the point we discussed a moment ago. It referred to the CEDAW Committee's recently adopted General Recommendation 12 on violence against women, but indicated that, quote, this is not seen to be binding, end quote. Canada announced its intention at a meeting of WEOG states, so states in the Western European and other group, but the response it received was mixed. Australia indicated that to some extent CEDAW already dealt with violence against women. New Zealand took the view that the focus should be on the implementation of existing standards rather than the creation of additional standards. And one UK official stated that surely violence against women is covered by existing instruments. But Canada continued to push on with the idea, and its initial draft resolution read, desirous of concluding a protocol on violence against women. However, the mixed reaction, further limited support. The resolution that was finally adopted recommended only that a framework for an international instrument be developed. So the proposal for a binding optional protocol to CEDAW had been downgraded. Regardless, for our purposes, the key point is that by 1991, there were 3 separate initiatives to try and address violence against women under international human rights law. And from the outset, you can already see that there were some tensions between 2 of them. Once it was agreed that instruments were to be drafted, for both the Inter-American Commission and the Commission on the Status of Women, the initial stage of the process was a turn to experts. And so in 1991, the OAS General Assembly expressed support for the Inter-American Commission's initiative. And following that expression of support, following that approval, the Commission convened an expert meeting to draft a preliminary text. And that meeting was held in August of 1991 in Caracas. A preliminary draft text was prepared, which the Commission considered and sent to states for their observations. The Commission on the Status of Women, the CSW, also opted for an expert meeting to consider the issue. And that expert group meeting took place in November in 1991 in Vienna. Canada prepared the principal working paper for that meeting, which was in fact drafted by Professor Rebecca Cook. And according to some of those who were present at the meeting, the paper reviewed the extent to which existing human rights treaties dealt with the issue of violence against women, and concluded that none of those existing treaties addressed the problem of violence against women directly, and that a new instrument was justified. The working paper reviewed possible approaches, possible instruments, and concluded that the drafting of an optional protocol to CEDAW was the recommendation. And that might be, as you recall, that was in fact Canada's earlier position. A quote-unquote lively debate followed, and that Canadian analysis was challenged. It was challenged by addressing the potential drawbacks of preparing an optional protocol to CEDAW. The concern seemed to be that an optional protocol to CEDAW on violence against women would suggest that violence against women was not covered by the CEDAW itself, not covered by the convention itself, only by the optional protocol. And since an optional protocol would only be binding on states that became parties to it, a certain subset of states may well be parties to CEDAW, but not the optional protocol. There was also reference to other initiatives that were going on at the time, notably the CEDAW Committee's intended study of violence, which was to be discussed in 1992. And so the expert group ultimately recommended as incremental approaches the strengthening of the CEDAW Committee's general recommendations on the subject, the adoption of a declaration on violence against women, and the appointment of a special rapporteur on violence against women. And it was said that only in the event that these measures proved unsuccessful in eliminating violence against women would an optional protocol be recommended. So the decision taken by the CSW expert group was very much affected of the CEDAW Committee to consider the issue of violence against women at its next session. The CSW expert group also prepared a declaration on violence against women, considering that to be an effective way to crystallise an international norm on the prohibition of violence against women. International women's human rights groups were also interested in taking the issue of violence against women forward. Donna Sullivan explains that women's human rights groups had a dual strategy of promoting the integration of women's human rights into existing instruments, as well as promoting new gender-specific standards. And she indicates that the approach to new standard setting was for many of us a cautious one, because she says we wanted to avoid the implication that existing norms could not be applied to various forms of violence against women. And so she says, therefore, broad claims about a complete normative gap, a complete gap in the law, would have been counterproductive. And that's the concern that really underlied the sort of critical reaction to the Canadian proposal, the idea that there was a complete normative gap, a complete gap in the law. Now, at the time, Sullivan was working for the International League for Human Rights, a US-based human rights NGO, and she prepared an initial draft of a general recommendation on violence against women, which she sent to Andrew Burns, who was working with the International Women's Rights Action Watch. Burns produced a revised draft, which was then submitted to Elizabeth Evatt, the member of the CEDAW Committee, who you might recall was preparing a draft general recommendation. But once that draft was handed over, there were limited interactions between Evatt and Burns and Sullivan about it. Now, recently, Nina Reiners has suggested that general comments, general recommendations of treaty bodies are drafted by what she calls a transnational lawmaking coalition, that is to say, with treaty body members and outside actors who draft these general comments together. I don't think that was the case here. What we see here is more akin to the traditional lobbying on the part of human rights NGOs. Elizabeth Evatt did prepare a draft general recommendation, and her approach was one of wanting CEDAW to be as wide-ranging as possible. She says that there wouldn't be any issue of violence against women which we couldn't bring within the framework of the convention. Now, the International League for Human Rights, the NGO I just mentioned, it held a seminar on violence against women shortly before the CEDAW Committee's 1992 session. So again, it's the middle column on the slide. That seminar was intended to help the CEDAW Committee members draft a legally oriented, a weighty general recommendation. Because until that point, the feeling was the CEDAW Committee had made more resolution-style recommendations. And one of the participants of the meeting recalls that the meeting informed much of the committee's work towards the recommendation. So again, here you can see that influence of NGOs coming through. Now, by the time the CEDAW committee session came around in January of 1992, there was a feeling in the committee that its plans had been preempted by the CSW expert group's proposal for a new instrument. There was a feeling that it may have been more sensible for CSW to wait and see what the CEDAW committee has said on the subject before embarking on a fresh enterprise to create a new instrument. But despite those concerns, the CEDAW committee revised and adopted the draft general recommendation that had been prepared by Elizabeth Everett, and that was what would become General Recommendation 19. Now, in March 1992, a month or so after the CEDAW committee adopted its general recommendation, the draft declaration of the CSW expert group was put before the CSW, the Commission on the Status of Women. And although CSW member states supported the draft, a number of them felt that it required further work. And so an intersessional working group meeting was established to further develop the declaration, taking into account the declaration of the expert group. Prior to the meeting of that working group, the International Human Rights Law Group, another NGO, circulated comments on the expert group draft to a number of states. The comments were prepared by Donna Sullivan, who had by this time moved to the International Human Rights Law Group. Now, the law group sought to downplay its role. It stressed that it was not submitting its work as an NGO statement, and it was not making a general distribution. Rather, the hope was that the delegations to which the paper had been sent, the comments had been sent, might pick up at least some of the suggestions and push them in the working group. And you can see actually on the slide that the words written statement had been crossed out, and instead what's been added is the phrase informal comments. And the comments of the law group would in fact play a significant role. In fact, some states treated the comments almost on a par with the draft of the expert group and drew on them in the formulation of their own states' positions. The intersessional working group meeting took place in Vienna in September 1992, and the working group revised the expert group's draft declaration, and the declaration was subsequently adopted by the CSW, then by the ECOSOC, and finally by the UN General Assembly in December of 1993. Back at the Inter-American Commission, after analysing states and others' comments on the preliminary draft Inter-American Convention, in October 1992, it was decided to convene an intergovernmental meeting of experts with a view to preparing a draft convention. There was a will to fast-track the preparation of that convention, with an eye to the 1995 World Conference on Women in Beijing, the idea being that the Inter-American Convention would be showcased as a hemispheric achievement. And aware of the work being undertaken at the CSW, the Intergovernmental Group of Experts was mandated to take into account the work being done by the UN on the issue. The Intergovernmental Group of Experts held 2 sessions in 1993, following which the text was approved and circulated to states for comments, and later adopted by the OAS General Assembly in June of 1994. So from 0 instruments at the start of 1992, by June of 1994, we had 3 important instruments on the subject. Specifically for international law, together, the 3 instruments made at least 4 important contributions. First, they recognised violence against women as a human rights issue, because up until this point, the limited initiatives that had taken place on the subject, particularly at the UN level, came out of the crime prevention and criminal justice spheres of the UN, not the human rights sphere. So we had an important shift through these three instruments. The second contribution is that the three instruments defined violence against women. And third, they recognised violence against women in all its forms. Up until this point, the limited attention had been paid to domestic violence, violence in the family. So an important, but only a subset of violence against women. And fourth, the three instruments recognise that states have obligations in respect of violence against women, also in the private sphere, thus breaking down that public-private divide. In my final few minutes, let me just say a few words on the definition of violence against women. So a particularly important feature of the three instruments is that they defined violence against women. As was noted at several points in the drafting processes, the definition of the problem was the first step in solving it. It was said that what cannot be defined cannot be legislated against. Now, initially, the drafters of the instruments adopted a bricolage type approach. That is to say, they simply drew on whatever materials they had before them, be they domestic laws, or studies, or guidance from expert groups. But once draft definitions of violence against women had been prepared, the drafters of the instruments quickly moved from bricolage to consistency. And you can see a comparison of the definitions on the slide. There's a very clear consistency across the definitions of violence against women in those three instruments. We can see similar sorts of elements, sort of harm, types of harm. We can see similarity in terms of wording, physical harm, sexual harm, psychological or mental harm, harm or suffering. We can also see a similarity even in the order of wording. And that again really goes to this point that these three instruments drafted at the same time should be seen together because the drafting processes were very much linked. And that comes through very clearly, I think, in those definitions. That's not to say that the definitions are identical. There are important differences between them. But again, it does demonstrate the relationship between the three drafting processes. And there are advantages and disadvantages of similarity of definition. In terms of advantages, there are pragmatic as well as normative reasons which might favour consistency across definitions or consistency of definition across instruments. In practical terms, it's far easier for drafters of an instrument to design an instrument and reach agreement on its terms if it uses language that has been used previously in other instruments, especially if those other instruments involve the same parties. That reduces the time it takes to reach agreement on particular wording, and consequently it reduces the costs. Normatively, consistent language might lead to harmonisation across international law. There's a shared understanding of a particular concept, and there's a shared approach amongst states, and that should in turn lead to, for example, consistency of definition in states' domestic legislation. And it's notable that some states parties to the Inter-American Convention have adopted the convention definition of violence against women in their domestic legislation. Others have used the convention definition as a baseline and broadened it out to include other forms of violence, notably economic violence and patrimonial violence. And as they've broadened out the definition rather than narrowed it, we still have a common core definition across states parties, namely that definition of the Inter-American Convention. And that consistency of definition has also enabled the argument that the prohibition on violence against women has passed into customary international law. It's easier to argue that the prohibition has passed into custom if the definition of violence against women, for example, in states' domestic legislations, is consistent across instruments. It's harder to make that argument if the definition varies widely across domestic legislation. But despite those very real merits of consistency of definition, there are also potential drawbacks. First, as Bruno Bizzati has cautioned in a different context, language might be reproduced unthinkingly, uncritically, almost by rote, right? We have a definition here, let's simply copy and paste it over here. And that overlooks potential limitations or ambiguities or gaps in the text. And we can see that perhaps with the concept of economic harm, which was omitted from these early definitions and only included a decade or so later in the Maputo Protocol. Second, we might need to think about the type of instrument we're dealing with, because what might be appropriate for a soft law instrument might not be appropriate for a binding treaty. Right? There's a difference between obligations which are binding and obligations or norms which we find in an instrument that's not binding. And third, if we take from the global level to the regional level, it might mean that regionally relevant issues are not sufficiently considered. So the Declaration on the Elimination of Violence Against Women, for example, lists among its manifestations of violence against women dowry-related violence and female genital mutilation, FGM. Now, those were dropped from the list of manifestations in the Inter-American Convention, presumably because they were not relevant to the region. However, regionally relevant manifestations were not added, despite some states, such as Trinidad and Tobago, suggesting inclusion of, for example, unlawful killing in the list of manifestations of violence, because in its view, that was very common in all societies of the region. Now, regardless of those potential drawbacks, the contribution of these three instruments for the understanding of the notion of violence against women should not be overlooked. So if I start to wrap up now, in conclusion, I think these three instruments do a number of things. First of all, as I said, from 0 instruments at the start of 1992, by June of 1994, so a little over 2 years later, we had 3 important instruments which had been adopted. But far from being a foregone conclusion, the process of creating those instruments were challenging in a number of respects. There were those institutional tensions between the CSW proposal and the work of the CEDAW committee. There was also a dialogue between the processes, with the Inter-American Commission process being mandated to take into account the work that was going on at the CSW. There was also that early setback with Canada's original proposal, protocol to CEDAW, simply falling away. The actors involved are also notable. Canada was the driving force behind the Declaration. The Inter-American Commission of Women was the driving force behind the Inter-American Convention. And Elizabeth Evatt was the driving force behind General Recommendation 19. Expert groups played that pivotal role in the drafting of in the early drafts of the instruments, following which state momentum quickly followed. And international women's human rights groups exerted quite a lot of influence, but all 3 processes were also spurred on by the then upcoming world conferences. The CEDAW committee selected the topic for its contribution to the 1993 World Conference on Human Rights. And Canada and the Inter-American Commission were keen on developing their instruments in time for the 1995 Fourth World Conference on Women. So the role of world conferences as catalysts for the preparation and adoption of these instruments should also be noted. And of course, finally, we should not lose sight of the particular moment in time in which these instruments were being drafted. The Cold War had ended, and this was a moment of resurgence for international law, also in other areas. And women's human rights groups had also done the initial work of placing violence against women and women's rights more broadly on the agenda of the international community. As I said, one of the important instruments of one of the important contributions of the 3 instruments is their definition. We've seen that although the drafters started off by opting for that bricolage type approach, they quickly moved towards consistency, and that consistency has had a number of advantages, but potentially also some disadvantages. And finally, paying close attention to how these instruments were drafted may offer some insight, not only for international lawmaking generally, but also the possible development of a global treaty on the elimination of violence against women, which is currently being considered. And with that, I will end there and I will stop sharing my screen.
Sandesh Sivakumaran for this very interesting analysis of the development of the recognition of violence against women, and also how the role that different actors have played, isn't it, in this development. So I have a lot of questions. Hopefully I will have the time to ask you at the end of the seminar. Now I hand over to Liliana Ronconi, Professor Liliana Ronconi, with her presentation, Where Have Girls Been? Lessons Learned and Challenges in the Agenda of Sexual Violence in the Inter-American Court of Human Rights.
Daniela, let me share my presentation. Can you see?
Yes, perfect.
Yes, one moment. Yeah. Thank you, Daniela, for the invitation. It's a great honor for me to be here, and thank you for generate this debate about this interesting topic. And thank you, Professor Sandy, for your amazing presentation. Following the line developed by the Professor Sandy, I will talk about something more specific. In this presentation, I want to talk about the advance of children's rights, sexual rights, and the state obligation in case of sexual violence against girls in the Inter-American Court of Human Rights. To this end, sorry, my point. To this end, first I will give an introduction, and then I will describe three cases resolved by the Inter-American Court of Human Rights. The case BRP versus Nicaragua, the case Guzmán Albarracín versus Ecuador, and the case Angulo Lozada versus Bolivia. It is important to highlight the significance of the BRP case, since it was the first to determine a state responsibility for violence against girls in a context of sexual violence. With this information, I will discuss the reparations that were ordered by the Inter-American Court. I am interested in focusing on reparation. Consider that these are not isolated cases, but only witness cases that reveal the situation of sexual violence against girls in the region. I conclude that exists clear standard to resolve cases that involve sexual violence and childhood. However, it is also possible to identify some inconsistencies in the Inter-American Court argumentation. My first point. The last decades was marked by achievement regarding the recognition of children's rights. Specifically, many countries in the region have ratified the Convention on the Right of Child, and have even approved internal or domestic regulation of the right of children. In addition, the state recognized the women's rights. In fact, a lot of Latin American states have assumed different obligations through the ratification of CEDAW and Belém do Pará Convention, as Professor Sandy explained, where these treaties are very important for the conceptualization of violence. And in certain cases, the state assumes similar obligation in their constitutional or legal system. However, there are worrying statistics regarding sexual violence against women, and specifically against young girls in the region. For example, a high rate of teenage pregnancies, femicides, and others. The Inter-American Court of Human Rights has protected women from sexual violence from the case Cotton Field onwards. And on the other hand, the Inter-American Court also recognized that boys and girls are subject of special protection on the case from the case Villagran Morales onwards. However, it is only recently, you can see here in 2018, that the Inter-American Court of Human Rights start to giving attention to girls' sexual rights. So, what are the standards developed by the Inter-American Court in case of sexual violence against girls? I was talking about 3 cases, but these 3 cases have some common characteristics. First, they involve girls who are victims of sexual violence by a family member or a close authority. Second, in all these cases, local authorities fail to provide a response in line with human rights standards, specifically intersecting rights of child and rights of women. And finally, this case involved girls who was lived in context of poverty. All of these 3 things are common circumstances in our region, no? The poverty, the situation of national justice, in local justice. And the first case is the case BRP versus Nicaragua. And in this case, an 8-year-old girl who was victim of rape by her father. Her mother learned the situation when she took her daughter to the medical center because she reported pain in the anal region. As a result, her mother denounced her father for the crime of rape against her daughter. As part of this criminal process, the girl had a medical examination in which she was re-victimized through various humiliating acts and degrading comments. Although the rape was proven, the father was released and declared innocent. In 2018, the Inter-American Court condemned Nicaraguan state for the violation of various human rights. And it is possible to highlight various standards developed by the Inter-American Court in this first case about this topic. First, lack of due diligence reinforced by gender and childhood condition in the criminal process for rape. The court has already developed a standard regarding the obligation of a state to guarantee due diligence in case of violence against women. But in this specific case, the court also understood that this due diligence had to be reinforced because the victim was a child. For that, the participation of girls in a process should not occur under the same condition as an adult. The state must guarantee the participation of boys and girls according to their abilities. This implies creating appropriate conditions to enable girls, boys, or adolescents to take part in the criminal process effectively. Other standard is the existence of institutional violence in the investigation of the incident. The court considered that the girl suffered double violence. On the one hand, sexual violence by a non-state agent, by her father. On the other hand, institutional violence during the judicial procedure, in particular, following the forensic medical examination and the reconstruction of the events. The state became the second aggressor, say the court. And all these acts, the court understood, imply the existence of cruel, inhuman, and degrading treatment against the girl for the application of the Article 5.1 of the American Convention of Human Rights. The court recognized that the treatment a victim received in the time of an investigation can in itself constitute institutional violence. And this point is very important because while in other cases, the court had used the concept of military institutional violence when the perpetrator were soldiers, here the concept is extended to the abuse the girl suffered during the investigation. However, the court does not give a definition of what institutional violence means, what this concept implies, its scope and limits. Other important standard is the existence of intersex vulnerability. The court determined that in this case exists a specific cause of discrimination because the victim was a child, was a woman. The court reiterated that children are considered more vulnerable to human rights violation, and the same with women. For that reason, the court understands that the state obligations are stronger. And the last standard, or important standard for me, is the discrimination in access to justice. The court understands that discrimination provokes impunity and facilitates a favorable environment for a violent act against women. In this way, the court makes clear the role that the administration of justice plays as a key actor in the eradication of violence against women. For all of these standards, this case is important because the court relates children and women's rights in context of sexual violence. The second case is the case Guzmán Albarracín versus Ecuador. And that case is important because it's the first case of sexual violence in an educational institution that the Inter-American Court resolved. Between her 14 and 16 years old, Paola Guzmán Albarracín suffered act of sexual violence from the vice rector of the school. Her school, the school was a public institution only for girls. The vice rector forced Paola to have sexual relationship with him as a condition to pass her course for almost 2 years. 2 days after turning 16, Paola commits suicide by taking pills that contain phosphorus. After she spent several hours in the school, her mother took her to the clinic where she finally died. After Paola's death, the investigation and judicial process suffered serious delay and irregularities regarding to stereotype relate to a stereotype regarding her action and her relationship with the vice rector, since she was considered to have seduced him. The acts of violence suffered by Paola were known by the staff of the educational community, even by its rector, who did nothing to protect her. Even during the time of the investigation of the case, several of Paola's classmates stated that they had been intimidated by many of these people in order to protect the vice rector. And at the same time, at the time of the event, various reports showed the high rate of violence and abuse toward boys and girls, particularly in the educational environment in Ecuador. The Inter-American Court considered that in this case, there was a violation of the girl right, here is girl right to a life free of sexual violence in an educational environment. It's a new right, apparently. The court, the standard developed by the court. First, the court recognized the obligation of the state to prevent girls and adolescents from suffering sexual violence in the school and to create safe educational context. As a consequence, states have the obligation of, first, establishing action to monitor the problem of sexual violence in educational institutions and developing policies for its prevention. And secondly, creating and implement simple mechanisms so that these acts can be reported, investigated, and punished. I return to this point in a couple of minutes. The court, the second standard or important standard, the court recognized the violation of judicial guarantee and judicial protection, among other things, for the use of gender stereotypes. The court held that the criminal process in Ecuador was plagued by stereotypes and prejudices against Paola. This decision in the local level holds that Paola, a girl, was responsible for acts of seduction that provoked the vice rector. Paola's honesty was questioned because her behavior wasn't what was expected of an honest woman. About this topic, about the stereotype, the Inter-American Court has developed in a lot of jurisprudence valuable standard on the role of a stereotype plays in the administration of justice. So in this sense, Guzmán Albarracín constitutes another step in the argumentative path of the Inter-American Court. But we can do some criticisms to this sentence, to this case. First, there is a step back in the consideration of what is understood by institutional violence, since the court didn't consider the events as a situation of institutional violence as it did in BRP case. It is clear that public school, like another state institution, can generate institutional violence. For that, a clear conceptualization by the court of what is meant by institutional violence in case of act of sexual violence against girls or boys is a key to develop this standard in the region. On the other hand, the court didn't recognize the existence of torture or cruel, inhuman, or degrading treatment against Paola. In the case of BRP versus Nicaragua, the court determined that the violation of the personal integrity, specifically the existence of cruel, inhuman, and degrading treatment. However, in Paola's case, it was expressly requested that the state be condemned by Turtle. The court stated that the evidence wasn't enough to satisfy all the requirements to recognize this violation despite the seriousness of the act of violence against Paola, which were reflected in her suicide. The court didn't analyze the element of Turtle as it had configured in its precedent, that is, the intentionality, the severity of the suffering, and the purpose. The court itself previously held that in order to analyze the severity of the suffering, it should have taken into account the specific circumstances of each case. To do this, the characteristic of the treatment must be considered, such as the duration or the way in which the suffering were inflicted, the physical and mental effect that they can cause, as well as the condition of the person who suffered suffering, including age, sex, and health status, among other personal conditions. All in all, this case represents some advances, for example, in the consideration of the stereotype or definition of the stereotype, and some step back linked with conceptualization of violence, institutional violence, and conceptualization of turtle or cruel, inhuman, and degrading treatment. The last case, here. The last case is a case Angulo Lozada versus Bolivia. In this case, it's important because the Inter-American Court developed consent standard as the central axis of the crime of sexual violence. Brice Angulo Lozada was a 16-year-old girl when she suffered acts of sexual violence, including sexual abuse and rape, by a cousin that went 10 years older than her. As a result of this event, she got depressed and she suspended her studies. Brice's father denounced her cousin on several occasions, and this led to various gynecological examinations which re-victimized her. The criminal proceedings could not continue because the accused left the country. In this case, the court reworks the obligation of due diligence and access to justice from the perspective of childhood and gender, as it had developed in PRP case. However, in this case, the court highlighted that since the criminal process involved a girl who was victim of sexual violence, the judicial guarantee of reasonable time should have been applied, acting without delay. It is also indicated that in this case, there was only one victim and one identified perpetrator. The argument of complexity in the process should be discarded. Moreover, unlike the previous cases, the court mentioned specifically the scope of a state obligation regarding consent from an intersectional perspective involving gender and childhood. In these cases, consent cannot be inferred, especially when there are inequalities in which the perpetrator is provided with power by institutional, work, or school environments, or by the possibility of depriving the victim economically, for example. Thus, in case of sexual violence, it's not appropriate to demonstrate resistance to physical aggression. Instead, a freely expressed consent is required in order to make the person's will clear. This also represents progress over BRP and Guzman Albarracin cases. In the first one, the consent was not discussed because the victim was an 8-year-old girl. In Guzman Albarracin case, instead, the court didn't refer to consent working on the stereotype that appeared when judging the vice rector conduct. In conclusion, Angulo Lozada case represented a great advance in terms of violence against girls and adolescents, as it made it clear that consent should not be presumed, but rather clearly demonstrated. This is in line with the progress that has been made at the regional level, for example, in the General Recommendation number 3 of the MESEXB. Besides following the line of PRP, the court recognized the existence of institutional violence due to the revictimization acts carried out by the state authority throughout the investigation. Again, in this case, it doesn't provide further details about its scope. In this sense, the debates are open. We can make some questions. For example, which acts are institutional violence? how it is distinguished from other type of legal qualification, who can be active subject of institutional violence. It is only about action or also in cases of omission. Why the acts suffered by Paola were not considered acts of institutional violence, but the acts suffered by BRP and Angulo Lozada were. I understand that this question and perhaps others are important when we need to define some act or certain acts, specifically into taking into account the standard that the Inter-American Court or the role that the Inter-American Court have in our region. Finally, following the line of BRP here, the court recognized the violation of personal integrity. Specifically, it held that the existence of cruel, inhuman, and degrading treatment. So that's the standard elaborated by the Inter-American Court. But although the court developed this relevant standard regarding the scope of the obligation of the state in case of sexual violence, I would like to highlight the importance of the remedy that the court ordered in these cases. The analysis remedies can show how the court view these cases, as the court view as isolated cases or, in the contrary, as a structural problem in the region. I will focus in two measures that are relevant, that for me are relevant. First, protocols. I will concentrate on the obligation of to sanction protocols. And secondly, I will analyze the obligation to provide training and courses. Regarding protocols, in BRP case, the court established that the state had to adopt, implement, and supervise 3 protocols that must be met for case of boys and adolescents that are victims of sexual violence. First, investigation and action protocols during the criminal process. Second, protocol on a comprehensive approach and medical legal assessment. And 3, a comprehensive care protocol. Subsequently, in Guzmán Albarracín case, the court established the obligation of the state to create protocols for situations of violence in educational context. In Angulo Lozada, it was again emphasized to need to create protocols similar to those established in BRP. In this way, the protocols became a tool that the court used a lot in case of sexual violence. However, it is important to keep in mind that the protocols provide guidelines on how to react in a specific case, but they don't modify the structural problem of violence, specifically when it has been normalized. That it is a tool that doesn't have a transformative spirit, since the protocols don't prevent situations of violence, but rather indicate how to respond to them. However, it is important to notice that in the Angulo Lozada case, went a step forward since the court established that after ordering the creation of protocols, the state has to create a system of indicators that allow measuring the effectiveness of the protocols. This information is relevant because it's not enough to sanction protocol alone. The state must also demonstrate the effective implementation and impact. Regarding training, in the case BRP, the court was established that the state should adopt and implement permanent training and courses for a public official who have the first contact with children of sexual violence, including those who work in the justice administration, as well as medical professionals and forensic doctors, so that they can receive training and the appropriate treatment of these victims during medical examination. These training courses should be also be extended to personnel belonging to the public health system, who in a second step are involved in the detention, diagnosis, and treatment of children and adolescents of sexual violence. Now, just as why with the adoption of protocols, the training or courses don't bring a transformative impact. If the state only focuses on the sanction of protocols or training regarding the reported action, there is not place for prevention. In fact, in many cases, children and adolescents are not even informed or instructed to identify that they are experiencing a situation of violence that can be reported. In this sense, I highlight the progress that Guzmán Albarracín and Angulo Lozada case represent, since in both the court focused on establishing the obligation of the state to guarantee comprehensive sexual education together with protocols and training. In Guzmán Albarracín specifically, the Inter-American Court emphasized the importance of the comprehensive sexual education, since Paola didn't have tools that would allow her to understand the sexual violence involved in acts she suffered. Consequently, the court understood the sexual education a suitable tool to enable girls and boys to have an adequate understanding of the implication of sexual and emotional relationships, particularly in relation to consent and the exercise of freedom regarding the sexual and reproductive rights. And in the case Angulo Lozada, the courts went in the same direction. So can I make some conclusion? I have shown the standard that the Inter-American Court had developed regarding sexual violence committed against girls. I mark the relevance of the ruling in the BRP case, which was emblematic and transcendental because it was the first, following by Guzmán Albarracín and Angulo Lozada. The court continued to emphasize the access to justice and the obligation to guarantee just due diligence in judicial process, but now focuses on girls for the first time. However, it is also possible to identify some inconsistencies that result in lack of clear guidelines for the state in the region. First, there are still conceptualization challenges concerning what constitutes institutional violence, and second, which acts imply torture or cruel, inhuman, and degrading treatment. Besides, although the court has mentioned the importance of prevention, it has not gone further in setting clear standards as regards preventing acts of violence against girls and boys. Thus, justice appears when the damage has already been caused, and it can only establish reparation for them. However, the advance that occurred in Guzmán Albarracín case regarding comprehensive sexual education and in Angulo Lozada regarding the importance of measuring the impact of the protocol show a search to transform public policy about sexual violence in the region. So